We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, helping both the public and lawyers since 1899. They are the largest suburban bar association in the country. The Nassau County Bar Association offers clinics where you can meet privately with an attorney to prevent or solve legal problems involving Hurricane Sandy, foreclosure, wills, or elder law. Speakers on almost any legal topic are also available to schools or community groups. They can also help lawyers advance their legal careers and offer a place to network. Learn more about the Nassau County Bar Association by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. We're talking about trusts and their consequences, and our guest is attorney Jeffrey S. Greener, and he's the partner in charge of the Trust and Estate Department at the Long Island law firm of Rifkin Radler, and one of the larger and more prominent law firms on Long Island. And he also is an expert in wealth transfer planning for those people that need to do so. Jeff, you were telling us about the various types of trusts and some other situations that may arise in terms of changing a trust or starting a trust, might be second marriages. So what are some of the implications there?
Trusts are especially effective in second marriages or later life marriages because clients often want to take care of their spouse but make sure that after their spouse is gone, the assets pass back to their children. If somebody leaves their assets outright to their spouse, or they own joint property with the spouse, when the first spouse dies, those assets belong exclusively to the survivor, and he or she can leave those assets to anybody they want to. With a trust, you can have your spouse benefit from the income stream generated by the assets, perhaps even get principal, but know that your wealth is going to go back to your heirs after your spouse is gone.
So you would temporarily give it to the spouse?
In effect, you're holding it on the spouse's behalf for his or her lifetime, for his comfort and maintenance and support.
So the trust will continue after your demise, continue to the next generation?
Correct. Or the trust might not even start until after you're gone. Your revocable trust or your will may create a trust for the benefit of the spouse to take effect after you're gone, and then terminate when that spouse is gone, or continue in further trust for your children or grandchildren if you think they need the protection of the trust.
And within a revocable trust, you talked about it a little bit before, but let's say your wishes change. Are you able to change what's in the trust?
With a revocable trust, you could change that all day long. Irrevocable trust, not so easy.
Okay. Are there fees to the trustee in a trust situation?
So New York state law has a statutory commission schedule for trustees, in the same way they have that for executors. And in the absence of any language in your trust to the contrary, the trustee would be entitled to fees every year and based on principal being paid out of the trust. Most of my clients who name a family member or a friend will ask those trustees to serve without compensation. And that's not to say that if you had an independent or third-party trustee, you couldn't come up with any arrangement that you want. In some trusts where I serve as trustee, I just serve at an hourly rate. So the family gets the benefit of lower payment structure.
And is there any accounting of the trust, either to a court or the government or to other beneficiaries? Any provisions by law or by operation of the trust?
So with revocable trust, there is none because they're your alter ego. Irrevocable trusts, if they earn income every year, they should file a tax return. If they're considered, grantor trusts or defective grantor trusts, that means all the income flows back to the grantor of the trust. There are some accountants who believe that you do not have to file an income tax return in those instances.
What if a beneficiary is concerned about the handling of the trust? Can they ask a court to look at it or to request an accounting through them?
Sure. So the trust might have language about whether accountings are mandatory or optional because of the cost of a trust, and given the fact that you may trust your trustees, you may not want to obligate them to file a formal accounting every year. But certainly beneficiaries, in most cases, have the right to look to what a trustee is doing and compel them to account, or go to court and compel them to account.
And would that be the surrogate's court?
That would be the surrogate's court of the county in which the trust is.
And what if your trustees had diminished or were unavailable? Is it normally some succession language, either by law or by the language of the trust?
In most cases, both. Some trusts name successor trustees, and we generally recommend that people try to name at least one successor. Sometimes trustees or third parties are given the ability to name successor trustees, especially in trusts that might last a generation or two or three. You'd want to give them that provision. When that fails, or if there are no trustees left, you can always go to the surrogate's court and ask that a new trustee be named.
And can you also have co-trustees, more than one person making these decisions?
Absolutely. Some people like to have more than one trustee for a check and a balance. Some people want to name a family member, but then they want somebody with a little bit more financial or legal or accounting experience. Sometimes people want to name an institution along with an individual, again, just to get the best of both worlds.
Are there any other differences or between revocable and irrevocable trusts that you want to mention?
Well, I'd like to point out a common misconception that revocable trusts somehow save our creditor protection or a Medicaid planning device. Generally, if you can get at your assets, your creditors can get at your assets. And with a revocable trust, you can get at your assets, so can your creditors.
In terms of drafting a trust, is this something that must be done by an experienced lawyer and not by going to a dinner seminar or getting a form out of a book or off the internet?
I don't think this is a do-it-yourself project. When you're dealing with your family and your finances, the two most important things in your life, I think using an experienced professional is money well spent.
And this way you can tailor it to your goals and needs.
Exactly. Everybody's situation is different, and to have a cookie-cutter format doesn't necessarily do you service.
And understand which options might be available to you.
Absolutely, both the pros and the cons, because there are both to every kind of a trust arrangement.
And just to go back to the cons, just summarize those cons again.
So one, with a revocable trust, they don't offer any creditor protection or Medicaid savings per se. With irrevocable trust, there's the cost of possibly having to file a tax return every year, and the issue that they may not be changeable, even though situations in your life may have changed, and then you're stuck with the terms of the trust.
And if you just have, let's say, real estate, is it possible to make some provision for that real estate without affecting your other liquid assets or your income?
Absolutely. You can put any one or more of your assets into a trust. Something that I did mention, trusts are particularly effective for minor children or disabled family members. When those people need protection, either from themselves or from others, a trust is a great tool to make sure that they will be taken care of for their lifetimes.
And also so the property cannot be taken by creditors or fall into disarray.
Exactly. It gives you long-term management and guidance.
And would there be any downside to that? You'd have to make sure it's okay with the lender, and it might eliminate the possibility of a reverse mortgage.
You know, that's the one issue, is the financing. But given the fact that you can now build in language that allows you to decant or change irrevocable trusts in certain instances, the trust is really a fantastic planning tool for just about everybody.
And that's another reason to go to a qualified attorney.
Sure. Don't try this at home. It's not
And is this something within the competence of, let's say, the general family attorney, or there's so much involved that they really need a trust expert or attorney who concentrates on that?
With life becoming more and more complicated, whether we like it or not, going to a specialist is probably your best bet. There are some very competent general practice attorneys. I started out as a general practice attorney, but given changes in the tax law, family dynamics, someone who has a lot of experience in this will probably get you your most bang for your buck.
And what happens in the event of foreclosure? Does this make it easier or harder to foreclose properties?
Neither really. If the trustee has if the lender has allowed you, first with a revocable trust, there's no distinction whatsoever. With an irrevocable trust, if the lender has given you the option to place the property in trust, they've probably reserved certain rights, or they've held they hold certain control over the trustee. So it's not necessarily going to give you a way to avoid that.
If a property is underwater, can you take advantage of either trust?
Again, with a revocable trust, you can, because the lenders can't stop you from placing it in trust. But with an irrevocable trust, you'll have a much harder time.
And then who would a lender look to for a shortfall? With a revocable trust, they would still look to you?
Yes, because you are typically both the trustee and beneficiary of your revocable trust. With respect to an irrevocable trust, they're going to look to the trustee as well as to the person who transferred the property to the trust.
And that's one key distinction. With a revocable, you're the trustee, so you have a right to change it really at any time for any reason.
Exactly.
Okay, and that's with irrevocable, it's important to name your trustees carefully.
Right. The less control and access you have to this trust assets, the more power the trust has for you.
And it's important for you to specify the rules for the operation of the trust.
Absolutely.
Okay, I wish we had some more time, but I'd like to thank Jeffrey S. Greener, who's the chair of the Trust and Estate Department at Rifkin Radler, for being our guest on Law You Should Know. And Jeff, just quickly mention the firm's website where someone can find out more about trusts.
So www.rifkin.com. Is it Rifkin or Rifkin Radler? I don't often Google myself.
Well, certainly Google would help them find it.
But if you Google me, Jeffrey Greener, as in the grass is greener, our website offers lots of information about trust and other forms of estate planning.
And just a reminder, listeners, whatever you've heard is presented as information only and not legal advice. You must get legal advice from your own attorney. And podcasts of this show are available by searching WHPC on iTunes. Please join us next week at the same time for another program on Law You Should Know on 90.3 WHPC, the voice of Nassau Community College, or also over the internet at nccradio.org.